Hey everybody, Paul Rabelais here. I'm an estate planning attorney helping people around South Louisiana or the entire state of Louisiana get and keep their legal affairs in order. And in today's video, I want to talk about the 2 reasons estates or successions or probates don't get settled or at all, or they don't get settled timely. It's a big issue, and sometimes it's a surprise, and sometimes due to family relationships, it just things kind of fall apart, or disasters happen. All those stories you hear about the probate that went bad. I want to talk about 2 reasons why they don't get done, and then at the end, I'll go over maybe what you can do to make sure those problems don't happen to your loved ones. Okay, so 2 reasons. In Louisiana, we call them successions. Other states call it probates. Generic term, just estates don't get settled. One is sometimes survivors of deceased people. Those survivors are unaware that a probate was necessary. So we see that sometimes, husband and wife, they own a home. The husband dies. She keeps living in the home for months or years or maybe even decades. Maybe she gets remarried, maybe she doesn't. But then one day it's time for her to sell the home, and she realizes she can't because she didn't complete her husband's probate. They bought the house while they were married. They bought it here in Louisiana as community property like most married couples do. And he died, and nobody told her that she needed to do a succession or a probate. And since nobody told her, she didn't do it. So then, they've got a buyer for the sale. The buyer's title attorney does a title examination, uncovers this problem, can't sell the house, and then now you're in a situation where they're wanting to do a succession fast. And I'll just tell you, the words probate and speed don't go real well together. So we see it in that circumstance. We see it maybe when someone owned a piece of rental property and they died. And yes, maybe the survivors did the succession to gain access to the money, but maybe they forgot about this rental property that the deceased had. Got to go back and amend and deal with the process all over again. Maybe people are unaware that they needed to complete a succession in Louisiana because dad or mom owned some family property. Dad owned 1/4 of this tract with his 3 siblings, and dad died, and so they weren't aware that they needed to do a succession to transfer dad's 1/4 undivided interest in that property, to perhaps dad's children or wherever it's supposed to go. Sometimes people pass away, they own property in another state, and the survivors will take the initiative to get that Louisiana probate or Louisiana succession complete to transfer all the Louisiana property and all the investments wherever they are. But that court proceeding doesn't transfer any out-of-state property in the deceased person's name. So they didn't know, or they forgot, or whatever about that piece of property, and then years later they're stuck with having to do that probate years later. What can make it even more of a mess is when the person with the property died, no court proceedings takes place, and then subsequent to that person dying, maybe one of the heirs passes away, and now you've got to complete 2 probates. Gets to be a real mess, a real nightmare. Sometimes people will pass away and they'll own maybe shares of stock in an account somewhere, or maybe they'll have some real old school stock certificates and the family wasn't aware of them. And so nothing gets done, and then lo and behold, they get discovered years later, got to go through that probate, then. So sometimes these things don't get done because families were unaware of the asset or of the need, and so years later you're stuck often having to do multiple probates, and depending on the circumstances. So that can be real challenging. The second reason estates don't get settled, and this is a pet peeve of mine is that there's many estates out there that have never been settled and probably will never be settled, because there is at least one, and it's usually one, but there's at least one uncooperative participant. Let me give an example. Dad died, he's got 4 kids. And, dad's stuff is going to the 4 kids. And he had a house, and maybe he had some other land, and he had some stock, and the family has to go through that court process to get dad's estate settled, to get everything divided up among the 4 children equally. The 4 children want to co-own the property. Maybe one or more wants to sell. Dad had 1,000 shares of stock. Everybody wants their 250 shares. But in order to complete that matter, a judge has to sign a court order ordering third parties, financial institutions, to divide up dad's assets 4 ways equally among the 4 heirs. But before a judge will sign that court order, a judge has to see all of the participants, not just a majority, not just the executor, but a dad has to see that all of the participants, every single one of them, has signed off on this petition asking a judge to sign the judgment. So consumers out there, and the kind of lay people, they kind of think that maybe the executor can ramrod, railroad, whatever that word is, run this thing through, or maybe, since 3 of the 4, there's only one bad egg, and 3 of the 4, that's a majority, so they ought to be able to get everything done. Doesn't work that way. Got to have everybody. That's when, in many cases, it's a real problem. And then you might have the one participant who for whatever reason says, I'm not going to sign anything until you fill in the blank. I'm not going to sign anything until I get my share of mom's china. I'm not going to sign anything until I see an accounting and all of the records. Maybe that one person is saying, I'm not signing anything until little sister apologizes to me for blank, fill in the blank. And to me, that's when I don't even like to be involved. In fact, sometimes we see some behavior which, no pun intended, is really childish. And that behavior, regardless of who's at fault and regardless of the years of history, will flat out stop an estate settlement in its tracks. And the funny thing is, sometimes they look to me to fix it. I can't fix those, nor do I want to even try to fix those issues. So, but those are, that one uncooperative participant can really stop an estate settlement in its tracks. So, what do you do in advance to try to avoid those problems? Well, on the planning side, if you're a mom or dad or parent or grandparent or anybody, and you don't want your survivors going through hell, for lack of a better term, one is, obviously you need to work with the right people and get things in order, and may have a good record of everything you own, and maybe even a list of instructions as to what they'll need to do to get it all settled, when you pass away. So on the planning side, getting it set up the right way, maybe you kind of can anticipate that there could be problems when you pass away, because you have some knowledge of your heirs' relationships or lack thereof. So there are some proactive things you can do to keep them out of the court process of getting things settled, to putting the right people in charge and giving them authority to do what they need to do to get things settled with little or no difficulty. So on that note, you can do a lot of things on the front end to eliminate problems on the back end. On the settlement side, after dad has passed away, maybe you are one of the 4 children and you don't want to go through a bunch of CRAP to get dad's estate settled, and there's some kind of relationship issues that are going to surface as part of dad's estate settlement. My advice to you is have very, very open communication. Two parts to this: open communication, and number two, from the very beginning. So don't say, well, we're going to get started on the estate settlement and we got this difficult sibling, and when it gets to the point where we need a signature, we're going to get some stuff done, but we'll go to them later. You know, and then they just stuff festers in their mind, and it just it gets to a boiling point where, you know, the point of no return. So my suggestion is take some initiative, have very open communication. You know, every email, every discussion with the attorney, every conversation, have it be with all of the parties. As a little bit unusual as that may seem, where every single email is a reply all email, and there's never any kind of conversations with an attorney or some third party behind the back of someone who wouldn't want you having that conversation. As long as that communication is really, really open, then the parties start to gain trust that things are going the right way. Everyone's included. This is going to be done the right way. It's going to be fair. There's no reason to cause fuss just to cause fuss. And that open communication from the beginning, from the get-go, can go a long way, you know, towards getting things settled on the quicker side versus the many, many years long side, and frustration and lawyers and courts and judges and flat out broken relationships that will never be repaired. So that's my maybe number one takeaway from this video. If you're a recipient of a bequest, maybe you're the executor or the trustee, and so you've been put in charge. As difficult as it may seem, get everybody, not just 4 out of the 5 involved from the get-go, but get all 5 out of 5 involved in the get-go. It may hurt a little bit on the front end, but it'll save tremendous difficulty on the back end. So hope that helps. A lot of estates out there not getting settled. My goal with this video is to make, you know, some people aware that you can do some things ahead of time and then at the time to really, you know, keep things positive, keep things moving in the right direction. Of course, I'd like to see you subscribe to my channel, and that'll keep you notified somehow by YouTube of future educational videos that we put out. Love to see you punch the like button. And then if you have any experience that you can share in the comments below, that would be fantastic. I always like to see that when people, you know, those constructive comments about where they can help others, you know, help themselves through the comments below. Okay, so I'm Paul Rabelais. I'm an estate planning attorney. Hope that helps. Have a great day.